Let's imagine that on Monday morning, you receive a request for information from a supervisor authority, not an inspection, an email of 3 lines. Please provide a list of artificial intelligence systems used by your organization indicated. For each of them, the purpose, the owner, and the role performed by your company under the regulation. How much time would you need in order to reply? In my experience, the honest answer that I receive from in-house legal counsels is the following: I do not know, because I'm not even aware of how many systems are in place. As of today, that email is possible. Welcome to Diritto al Digitale. I'm Giulio Coraggio, a technology data lawyer at the global law firm DLA Piper. In this episode, we shall discuss the date of the 2nd of August 2026 and the misunderstanding growing around it. What becomes actually applicable under the UAI Act, what has been postponed because of the Digital Omnibus package, and above all, the operational implications for those who, within companies, have to translate all of this into decisions. I'm addressing in particular those of you who work in-house, since you are most likely the ones who have already flagged this issue internally and who now have to put it back on the agenda. On the 27th of July, the Regulation 2026-1744, the so-called Digital Omnibus on AI, entered into force, amending the UAI Act just a few days before its main date of application. The intervention follows the so-called Draghi Report and the debate on European over-regulation. The purpose was to simplify. The outcome for anyone who has to build a compliance plan is considerably more articulated. The point to be fixed is the following, and I would suggest to use it literally when you discuss the matter internally. The Digital Omnibus has postponed the obligations relating to high-risk AI systems. It has not, however, modified the general date of application of the UAI Act, which remains the 2nd of August 2026. Both statements are true at the same time, and the mistake that I see spreading, including memoranda circulated by advisors, is the improper summary according to which the AI Act has been postponed. This is not the case. Let us enter into the merit. As of the 2nd of August 2026, 3 matters change. Firstly, the enforcement powers of general-purpose AI models. The EU Commission and the UAI Office obtained the power to investigate and sanction the providers of general-purpose AI systems with fines up to €15 million, or 3% of the worldwide turnover. The substantive obligations applied already since August 2026. What is activated today is, however, the sanctioning apparatus. Second point, the transparency obligations under Article 50 of the AI Act become enforceable. I shall come back to them later, since they affect the largest number of organizations and even individuals. Thirdly, the whole sanctioning framework becomes operational, and national market surveillance authorities may enforce all the provisions already in force. This includes also Article 5 on prohibited practices and Article 4 on AI literacy, applicable since February 2025, but so far without a fully active enforcement mechanism. A remark on this last point, however, is that the Digital Omnibus has mitigated the AI literacy obligations. It's now sufficient to adopt measures aimed at supporting its development, without guaranteeing a specific level. This is a real simplification, but not a repeal, and documenting the training initiatives remains the easiest manner to evidence compliance. In my view, Article 50 is the most underestimated obligation of this phase. For a structural reason, it does not presuppose a high-risk system, and therefore it remains outside the classification exercise that has absorbed most of the work of the last months. Let me summarize its scope, since this is a checklist that you may circulate to the business already from today. Those who provide systems intended to interact with natural persons shall ensure that the artificial nature of the system is recognizable, unless evident from the content. Support chatbots, voice agents, virtual assistants, and avatars shall have this kind of disclosure. Synthetic contents shall be labeled. AI-generated text published in order to inform the public on matters of general interest shall be declared as such, unless a natural person assumes the editorial responsibility. And those deploying emotion recognition of biometric categorization shall inform the individuals concerned. Two operational remarks, however. The machine-readable marking under the second paragraph does not apply to the systems already placed on the market before today, for which the deadline is the 2nd of December 2026. On the contrary, the information towards individuals is enforceable immediately. The second remark is the argument that I usually raise with CFOs. What we are dealing with the least expensive compliance measure of the entire UAI Act, a line of text within an interface to defend before a board the failure to adopt a measure whose cost is one day of development is a position in which I would not like to be. I now move to the point that I consider the most relevant for your role. I'm talking to the in-house legal counsels, since it moves your organization from one regime to another without anyone having taken such a decision. Indeed, the enforcement on general-purpose models does not concern exclusively the large developers. A deployer may be requalified as a provider. An deployer is a company exploiting AI systems, and this requalification occurs when the organization customizes a system for its own purposes, trains or fine-tunes it on its own data, or places it on the market under its own name or trademark. The substantial modification of a high-risk AI system leads to the same consequence. And the consequences are not merely formal. You move from the relatively limited set of obligations of the deployer to the full regime of the provider, with everything that follows in terms of technical documentation, conformity assessment, and exposure to sanctions. I would therefore suggest a very concrete exercise. Take the list of AI projects approved during the last year and verify how many provide for a fine-tuning on proprietary data or for a release under the corporate brand. In most of the organizations with which I work, such verification has never been performed, and the outcome usually surprises whoever has requested it. Now, let's review the postponements, which I assume you are aware of. The high-risk systems under Annex 3, employment, credit, education, essential services, biometrics, critical infrastructures, law enforcement, migration, and justice, shall apply as of the 2nd of December 2027. Those under Annex 1 embedded into regulated products as of the 2nd of August 2028. The national sandboxes as of the 2nd of August 2027. As of the 2nd of December 2026, a new prohibited practice is instead introduced, the so-called nudification. Systems intended to generate non-consensual sexual or intimate content and child sexual abuse material are caught by this ban. For those of you dealing with platforms and contents, this is a matter to be immediately included in the roadmap of moderation processes. I would also point out one simplification of practical relevance. The notion of safety component has been limited to the systems aimed at preventing or mitigating risks for the health and safety of persons, with the exclusion of mere user assistance, performance optimization, and quality control. This might remove from the high-risk perimeter more systems than one would expect. Therefore, it's advisable to review the classification performed before July. In any case, the postponement does not represent a relief. The technical documentation, the fundamental rights impact assessments, and the requalification of the agreements with suppliers require between 6 and 12 months of work. Moreover, the inventory that you shall need in December 2027 is exactly the one that an authority might request already this year. And here I come to the reason for which I wanted to record this episode. In my experience, obstacle is almost never the text of the regulation. You are familiar with the text. The obstacle is that with organizations, AI compliance does not belong to anyone. Either it's spread among legal, IT, security, procurement, marketing, and the business lines, with each of them assuming that somebody else will be dealing with it. Or, and this is the more insidious variant, since it has the appearance of a solution, it's entirely allocated to the IT department, which maps the systems and implements the controls. An essential contribution. But it is not the function equipped in order to determine whether a use case falls under Annex 3, whether a fine-tuning has led to a requalification, or whether a disclosure under Article 50 is legally adequate. There are legal qualifications taken by default by individuals who have never received such mandate. I would also mention two arguments that I assume you have already heard, since I hear them constantly. The first one, but these systems are used by everyone. This is the most frequent objection and also the weakest. The circumstance that a tool is widely adopted does not say anything about how the same is actually used within your organization, on which the data has been trained, and which function it performs. Moreover, the widespread breach of an obligation does not constitute a justification. On the contrary, it increases the likelihood of an intervention by the authority, and at that stage, somebody should be the first case. The second argument is more subtle. A number of organizations select the tool with considerable rigor. Due diligence on the supplier, negotiated agreement, preliminary assessment, and then they do not monitor anymore how the system is used within your organization. The system is introduced for a given purpose, and then 6 months later, it's serving a different one. Nobody has taken such decision. But compliance is not assessed on the basis of the purchase agreement. It's assessed on the basis of the actual use. And the actual use within a considerable number of organizations is not monitored by anyone. If this description sounds familiar, the issue is not yours, but the solution passes through you, since you are the only function having visibility both on the legal risks and on the decision-making process. Let me conclude with that. Very pragmatically, I would suggest to include in a board paper during the coming weeks. Number 1, the inventory of AI systems in use, including shadow AI, the purpose, the owner, and the role performed by the organization. Everything else depends on it, as well as your ability to reply to a request from an authority. 2, the formal allocation of the responsibility. An AI committee with a defined mandate, an escalation path, and minutes decisions involving legal, IT, compliance, audit, security, and the business. We have dedicated a specific episode of this podcast to this establishment. Number 3, the assessment under Article 5 and 50, which has the closest deadline and the lowest cost. So we're talking about the labeling, the disclaimers that need to be present when an AI system is interacting with an individual. Number 4, the assessment of the potential requalifications by means of the exercise on the projects of the last year. So requalification between a deployer and a provider. Number 5, the launch of the high-risk workstream. to be justified before the board on the basis of the time required, rather than the deadline. And above all, please document the decisions taken. During an inspection, a dated record of what has been assessed and of why a given option has not been pursued is worth considerably more than an impeccable policy that nobody has applied. The question that I would raise before any board of directors, and that I suggest you do raise yourself, is a very short one. Is there anyone with a name and a surname accountable for AI compliance within this organization? If the answer requires more than a moment, that is the first item of the agenda. So just to conclude, the 2nd of August 2026 is not the compliance cliff that the market was expecting. It's the moment in which the enforcement begins in relation to the obligations that have been silently accumulating since February 2023. For organizations having an accountable function, the matter is manageable, and under several aspects, it represents a competitive advantage towards clients and partners that are beginning to request at the contractual stage. For the others, the postponement to December 2027 shall pass exactly in the same manner as the last 18 months. You wish to discuss how the situation appears within your organization, you may just find my contacts at dlpaper.com. I'm Giulio Coraggio. This is the podcast Diritto al Digitale. Thank you for listening. Arrivederci.